Hello everyone. Today we will learn about financial reporting and the Securities and Exchange Commissions. After finishing this chapter, you will understand the origin and the role of the SEC. You will also learn the purpose of different type of federal securities laws, and you will learn a detail about the Sarbanes-Oxley Act and the responsibilities of the PCAOB. We will also discuss the SEC's role in establishing GAAP and different types of filings such as 10K, 10Q. You probably are familiar with this. We will also learn about 8K, proxy statements, and the entire registration process, and of course the importance of all these responsibilities that the SEC is performing. So let's start. So the Securities and Exchange Commission is established to protect investors' interest. When you invest in the capital market, then you have to make sure that your invested money is properly utilized. So the world of investing is fascinating, and of course at the same time it is complex because public limited companies are playing with all these investors' money. So this Securities and Exchange Commission is established to ensure that investors' interests are protected. This is an independent agency, and this agency has direct authority to all public companies. This SEC is established by the SEC Act, Securities Act of 1934. And SEC has of course major influence on the development of US GAAP. So it also mandates that all public companies will disclose all required information in a timely manner. So this SEC is composed of 5 divisions and 23 offices. So you need to be familiar with these 5 divisions, and you will also learn that all these 5 divisions, they all have the heads, and these heads are appointed by the President of the United States, and they serve 5 years scattered terms. And no more than 3 of these individuals can belong to the same political party. And the chairman is usually from the same political party as the president is. So now we will talk about these divisions and what's their role, and a little about the major offices. But one information I want to let you know that this SEC actually collects huge amount of fees from public companies, and it is considered as one of the major revenue source for US government. So I have a little old data, and in 2012 you see that the SEC actually deposited over 1.6 billion fees in US Treasury. So now let's talk about these divisions. There are 5 divisions and 23 offices. So one of the most important division is the division of corporation finance, and this division has the responsibility to ensure that publicly held companies meet all disclosure requirements. The other division is the division of trading and markets. This division actually oversees the securities markets in the country, and it is also responsible for registering and regulating the brokerage firms. The third division is the division of enforcement, and this division helps to ensure compliance with federal security laws. And this division also investigates possible violations of security laws and recommends appropriate remedies. That means they can investigate different type of corporate frauds, especially that could be related to insider trading, misinterpretation or omission of any important information, or manipulation of any information that can influence the stock price. The fourth division is the division of investment management that actually oversees all investment management companies and administers the securities laws that affect the investment companies, and especially those includes mutual funds and investment advisors. The last division is the division of economic and risk analysis. So this division assists the SEC in efforts to protect investors, maintain efficient markets, and facilitate capital creation. So this division actually interacts with all other SEC divisions and offices and provides access to sophisticated economic and risk analysis to help advise and inform policymakers and rule makers. Now let's talk about the offices. As I mentioned, there are 23 offices, but 3 are very important and you should be familiar with this. One is the Office of Information Technology, and this office actually supports the SEC and its all staffs in all aspects of information technology, and they operates the electronic data gathering, analysis and retrieval, and we will learn a little about it. This electronic data gathering, analysis and retrieval, this system is also known as EDGAR, EDGAR. There are a couple others important offices. These are the Office of Compliance and Inspections and Examinations and the Office of the Chief Accountants. Now let's talk about the federal securities laws. So after the Great Depression, Congress enacted 2 primary pieces of securities legislations that are designed to restore investors' trust in the capital market. So one of the most important laws, and that's one of the first laws, is Securities Act of 1933. So this act is also referred as the Truth in Securities Laws, and that regulates the initial offering of securities by a company or underwriter. And the other law you need to know, that is the Securities Exchange Act of 1934, which actually created the SEC. And this act actually regulates the subsequent trading of securities through broker and exchange. So to summarize, this 1933 Act actually regulates the initial offering, first time when a company will go to public, and the 1934 Act actually regulates all those subsequent trading, and they ensures again that investors' interest and are protected and all informations are fairly disclosed. Now here let's talk a little about the goals of the SEC. Over the years, the SEC actually has attempted to achieve several interconnected goals. So it of course ensures that full and fair information is disclosed to all levels of investors. It prohibits the dissemination of materially misstated information. It prevents the misuse of information, especially by inside parties, and it also regulates the operation of securities markets such as the New York Stock Exchange. It not only regulates the NYSE, it also regulates the over-the-counter exchanges. Now here we will talk a little about the accounting scandals. We all know what happened in 2001 and 2002. All those scandals we'll talk again when we will discuss the Sarbanes-Oxley Act, especially the Enron and WorldCom disaster. You probably are also familiar with our recent economic crisis that happened in 2008. So what are the major reasons that actually causes these scandal? There are actually unlimited number of reasons, but some of them are agreed by the corporate executives. They can exploit the investors, they can misuse their invested funds just to meet their own greed and own demand. And of course we can blame the corporate governance system of a company. If the corporate governance system is not strong, then definitely this type of a scandal, this kind of fraud can take places frequently. So of course we can also talk about the role of the accounting firm. We always hear about auditors' independence, but if the accounting firms fail to provide appropriate quality control measures or appropriate independent auditing, this type of occurrence can occur. We can also talk about the shortcomings of our accounting standards, whether our GAAP or the accounting standards are enough to self-regulate the accounting professions. Also, sometimes market expectations could be blamed. Sometimes there are unreasonable market expectations. Sometimes analyst forecasts or other pressures, outside pressures, can make the executives to take this type of decisions. And of course, I can talk about the ability of the SEC, whether SEC is overburdened with their workload or this small agency is not enough to handle all these public companies. So there are several reasons. So again, you will see that there are different type of securities acts that actually make sure that all these types of accounting fraud and scandals could be protected. So now we will discuss the major securities acts. We also got some idea about the Securities Act of 1933, which is about the IPO or new securities, new registrants, and about the Act of 1934. So now we'll focus on few other acts. One of them is Public Utility Holding Act of 1935, and this act requires the registration of interstate holding companies of public utilities. Then another important act is Trust Indenture Act of 1939. So this act requires the registration of trust indenture documents, and those are actually related to the sale of bonds, indentures, notes, or any other type of debt securities. And then we will learn Investment Company Act of 1940. So this act actually requires registration of investment companies, and that includes mutual funds because they play a significant role in capital market. So this act actually deals with these mutual funds and that are engaged in investing and trading securities. And other act that just try to be familiar with all these acts, and you see that how those acts are developed, and it's kind of the chronological order, what started in 1933, and now the next act is the Investment Advisors Act of 1940 and Securities Investor Protection Act of 1970. So these acts actually require investment advisors to register and to follow certain standards created to protect investors. You will also see a few other acts here. One is the Foreign Corrupt Practice Act of 1977, and this act requires the maintenance of accounting records and adequate internal accounting controls. Other important act is Insider Trading Sanction Acts of 1984 and Insider Trading and Securities Fraud Enforcement Act of 1988. And later we will learn the last act, which is of course not the least, is the Sarbanes-Oxley Act, which is the Act of 2002, and the creation and the role of PCAOB. So you probably have heard the name of this organization, which plays a critical role. The role is kind of the watchdog of all public auditing firms. So now let's see what's the SEC's impacts on financial reporting. So here you will see that SEC, of course, the SEC's disclosure and accounting requirements are not related to the filings. Of course, they have some other responsibilities, and they want to make sure that financial statements must be audited. And in addition to the audited financial statement, there is one rule, SEC's Rule 14C3 of the 1934 Act, that requires that all public companies will disclose some other information in their proxy statements, and this information includes 5-year summary of operations, and they should mention here their sales, assets, income from continuing operations, and cash dividend. So companies must need to provide a 5-year summary. Companies also need to mention in their proxy statement the description of the business activities, including their principal products and sources and availability of raw materials. They also need to provide 3-year summary of their industry segment, if they have any export sales or foreign operations. The companies also need to list their directors' names and executive officers. And here they also need to mention the market price of the company's common stock for each quarterly period within the 2 most recent fiscal years. And the companies also need to mention about the restrictions of the company's ability to pay dividend. Now, Rule 14C3 also requires to mention one analysis which is very important. It's called MD&A, which is management's discussion and analysis. And here in this part, company needs to describe about their financial conditions, or if there is any major changes in financial conditions and the results of their operations. These MDA discussions can also include the liquidity trends and significant events, and if there is any changes in their financial statements, what are the reasons, what are the impacts. Also, they need to mention if there is any impact of the inflation on the company. So these are the required information by the Rule 14C3 in addition to the audited financial statements. So here, the information, of course, all this information that are required by SEC, they help to ensure that the true independence is established, right? And here, SEC also requires these disclosures, and these disclosures is about their auditors. So SEC requires that all public companies will disclose all non-audit services provided by the audit firms. They also need to disclose a statement as to whether the board of directors or if the company has any audit committee, they approved all non-audit services after considering the possibility that such service might impair the external auditor's independence. So auditors, of course, will audit the financial statements, but sometimes they can perform some non-audit related tasks. So the public companies must need to disclose that. Of course, they also need to disclose the percentage of non-audit fees to the total audit fees. And the last item that they need to disclose, which is that the individual audit fees, non-audit fees, if any non-audit fees is more than 3% of the annual audit fees, they need to disclose that. Now we will talk about the Sarbanes-Oxley Act, and before that I want to remind you about all these accounting scandals that took place in early 2000s, and that actually led the Congress to take this act. So we all know about Enron's, right? So Enron's former chairman and chief executive, he received more than 150 million in payment and stocks in the year leading up to the company's collapse. And if you can remember about the WorldCom's scandal, so former WorldCom CEO, he borrowed 408 million from the telecommunication companies, and they actually improperly accounted for 9 billions, and later the company was forced to bankruptcy. And another scandal that is related to the Adelphia Communications, and their CEO actually allegedly conspired with 4 other executives to loot the company more than $2 billion. So all these accounting scandals, accounting frauds actually impacted the economy, whole US economy. And to protect this type of behavior, Congress passed the Sarbanes-Oxley Act in July 2002. So this Sarbanes-Oxley Act is kind of a response to all these accounting scandals. And in 2002, the Act actually established one board which is known as the PCAOB, or Public Company Accounting Oversight Board. So this PCAOB, this actually ensures the auditing quality and auditors' independence, and they are also conduct like periodic inspections of all public accounting firms. So basically these organizations, PCAOB plays the role as the watchdog of the all auditors. So now we will learn a little about the composition of PCAOB. So they should have 5 members, and only 2 of them, of these 5 members, will be CPAs or accountants, and the remaining 3 must not be accountants. And this board actually enforces auditing, quality control, and independence standards and rules, and it is under the oversight and enforcement authority of the SEC. It is funded from fees levied on all publicly traded companies. Now all accounting firms, they must to register with this PCAOB. So we'll talk about the registration process of public accounting firms with this PCAOB. So the registration of public accounting firm is required, and it is required only of the firms that prepare, issue, or participate in preparing an audit report for an issuer. So consequently, we'll see that all public accounting firms of significant size must register. You will see sometimes the small accounting firms, they don't need to register. Foreign accounting firms that play a substantial role in the audit of an organization that has securities registered in USA also must register with the PCAOB, and they also need to follow the Sarbanes-Oxley Act. And of course, this act has a significant impact on the activities of foreign companies that sell their securities on US market. Now we will again talk about the Sarbanes-Oxley Act, and the application process for PCAOB's registration provides the oversight board a significant amount of information about the audit firms, and all these, the act is the Sarbanes-Oxley Act and the PCAOB ensures again the auditor's independence, and for every audit firms, they must need to identify their audit clients, and they also need to provide the information to the PCAOB board, a list of all accountants that they will be doing their audit reports, and whatever the annual fees they receive from each of their clients. And all public accounting firms must need to report to the PCAOB that if there is any information about any criminal, civil, or administrative actions pending against the firm or any person associated with the firm. So now here again, the PCAOB and Sarbanes-Oxley, they want to ensure auditors' independence. So here I want to focus on one part of this Sarbanes-Oxley or SOX Act, which is Section 201. And the Section 201, according to the Section 201, some of the tasks are now prohibited. So here, certain services that could previously have been provided to an audit client are now prohibited, and these are bookkeeping service or AIS design and implementation, appraisal or valuation service, internal audit outsourcing, or any HR related functions, investment advising, legal service, or any expert service. So before 2002 these were allowed, but now SOX Section 201 prohibits this type of services. Now here, SOX also requires that public firms should have an audit committee, and this audit committee, the main goal of the audit committee is to resolve conflict between the auditor and management, and audit committee will also be expected to exercise more oversight in the future. The committee is responsible for the appointment and the compensation of the external auditor, and now the auditors after this SOX Act, auditors need to report to the committee, audit committee on their boards, not to the management. And the Sarbanes-Oxley Act also requires that the lead audit partner must be rotated off after 5 years. Now here we are talking all about SEC. Remember that SEC always has the authority over FASB or over GAAP, and we will talk about 2 basic documents that's also required by the SEC. And here we will talk about this disclosure document and the 2 most important basic disclosure document, which are known as Regulation SK and Regulation SX. So Regulation SK established requirements for all non-financial information contained in filing with the SEC. On the other hand, Regulation SX, these are the prescribed form and content of the financial statements. And of course, it includes not only the basic financial statements, it also includes all type of notes and schedules, and this includes various type of filing. So before being accepted, all financial information must meet a number of clearly specified requirements established by this regulation, Regulation SX. Now, if you look at this chart, you will see how SEC can practice their authority over GAAP. So Congress has assigned GAAP setting authority to SEC. So it's basically SEC is the boss. So they actually ask the FASB, Financial Accounting Standard Board, to set these accounting standard, which we call in USA US GAAP. So FASB does not have any enforcement authority. They just prepare the standards, and then these standards can be overridden by the SEC, and SEC is the authority that ensures that these accounting standards are followed by the public firms. And of course, the SEC also has the authority to all those public traded companies to ensure the fair and timely disclosures. Now here we talked about SEC's authority over GAAP, and we also talked about these Regulation SK and Regulation SX, and here we'll talk a little about 2 other types of information source that SEC has issued. One is financial reporting releases, and which is known as FRRs, and these are the supplement to Regulation SX and Regulation SK. And another is, in addition, the staff of the SEC publishes a series of staff accounting bulletins or SABs, and these are also the means to inform the financial community of its position. So now here we will also discuss about a little about the additional SEC's authority. So basically SEC of course requires definitely the basic disclosures which we discussed so far, but SEC can require any additional disclosures, and SEC can establish any type of moratorium or any temporary prohibitions on a specific accounting practice. It can challenge anytime any company for any individual statements, and of course what I discussed before, that SEC can overrule the FASB, or SEC can override or overrule the GAAP. Now here we will talk about the filing process, and we will talk 2 basic type of filings. One is related to the registration filings. That means when the firm wants to issue the securities, it could be new registrants, that means the IPO related registration, or it could be like seasonal securities. And later we'll talk about the periodic filings. And remember what I mentioned earlier, all public firms must need to pay fees to the SEC, and this is a huge amount of revenue source for the federal government. So in 2013, SEC actually SEC decided that for every 1 million of security offerings, they will charge $136.40, which is huge, right? Usually public companies, they have huge amount of security offerings, millions, billions dollars. So you can imagine how much SEC can collect only from one public company's initial offerings. And these fees, this huge amount of fees, is of course one source of government revenues, but there is a huge debate whether SEC is actually overcharging for these registrations, or again there is another debate that SEC needs to ensure all type of fair disclosures and to protect investors' interest. So whether this amount is sufficient fund for SEC. So there is a huge debate whether this type of cost and charge are justifiable or not. Now here you will see few common SEC registration forms, and depending on different scenarios, companies will decide what type of form they're gonna use. S1, which is very common, the most common one for new registrations, when the public company, when any company wants to be public for the first time, they will use this form. And S3 is another type of form used by large companies which already has a significant following in the stock market. S4, this type of form is used for any type of business combination, merger type of transactions. S8 is used for employee stock plans. S11, this type of form is used for real estate companies. So here we'll talk a little about the registration process. So the actual registration process is long and time consuming. It is composed of a series of events leading up to the SEC's permission to go effective. So basically what the companies will do, they will select the appropriate form and they will accumulate all information and that they need to complete all these forms, and for the especially for the requirement of regulation SK and regulation SX. So once they collect all information, they complete all those appropriate forms, the companies will send those forms to the SEC. So when the SEC receives these forms, the Division of Corporation Finance plays the important role. They actually reviews all those registration related forms and statement, and then one analyst from this Division of Corporation Finance, they actually determines whether all non-financial information compiles with the SEC's disclosure requirements in regulation SK. Remember, regulation SK is related to non-financial and SX is related to financial statements. So then the Division of Corporation Finance regularly request for further classifications. They can ask for any change or any additional information, especially for the case of initial registration. That means when a firm is going to be public for the first time, they're doing their IPO, this division will ask them to make any change or further classification, and they actually issues one letter. It's called letter of comments. Also it is known as a deficiency letter, and they will ask the company that we need this type of clarification or this type of information. So usually companies, they will provide the necessary data or they will make the necessary changes what the division will suggest. And then when finally the division will feel that the Division of Corporation Finance is satisfied and feel that the company has fulfilled all SEC regulations, then the registration statement is made effective, and then the company can sell the securities. So here, remember, this process is time consuming and expensive, and the division can issue several times the letter of comments, and it may take time for the companies to resolve all these issues. So sometimes the company can start a discussion directly with the SEC in hope of resolving the problems without making the requested adjustment. statements, but most of the cases the registrant or the company tries to provide the necessary information to expedite the process. So here again I'll talk a little about the registration process. So once the company will go through all this process, the registration, and when they will prepare the registration statement, they need to ensure two parts. So part one is also known as prospectus, and all companies they want to be public or they are going for the first time registration, they will prepare this prospectus, and this prospectus actually contains extensive information about the company. Definitely it will include financial statements for the issuing company, and that must be audited by an independent auditor, and of course they need to provide the supplementary information. Also, the company needs to provide an explanation of the intended use of the proceeds to be generated by the sale of the new securities. Then the company needs to provide a description of the risks, if there is any specific risk related to the securities that they are going to sell. And of course, the company will provide a description of the business and the properties owned by the issuer. So these prospectus the company must need to prepare, and this is considered as the first part of this registration statement. The second part of this registration statement is basically for the informational needs of the SEC staff. This prospectus is for the public, right? It will be distributed to all potential investors, but for part two, this registration statement is only for SEC staff, and basically if any additional data should be disclosed about the company and the securities, for example marketing arrangements or the expenses of issuance, sales to special parties, or this type of information SEC can ask the company to provide here in part 2 statements. So now here we will learn about the periodic filings. So far we discussed the registration process. That means when the firm is going to sell their securities publicly. Once the firm is registered, then the public firms need to provide this periodic filing. We all are familiar with 10K, which is the annual report, 10Q, which is the quarterly or interim report. And one major difference is that 10K is audited by an external auditor, but 10Q, that means quarterly reports, are not required to be audited. And here you will learn another new type of form, which you will see that companies frequently file this type of forms with SEC. This is known as Form 8K. So this form is used to disclose if there is any unique or significant happenings. So basically this 8K form is not filed at a regular basis, but usually if any event happen, then it is required to issue this form within 50 calendar days of that event, or there are certain specific instances that requires to issue this form within 5 business days. So this form 8K may be filed to report any action that the company believes that this information is important to the investors. For example, if any director resigns the company, they need to submit this form and let the public know. Or if there is any change in control, or if there is any significant acquisition or disposition of assets, even if they change their auditor, they need to file this form and let the people know. And of course, if there is anything happened, for example bankruptcy or any type of major event, major change, then they need to provide this form. They need to file this form, and you will see at the end of this chapter you need to do one small case study. I already provided the information in week 2 module. Here you need to search a company filings, of course 10K, 10Q, and of course 8K. If they issued any 8K recently, you will be searching the filings through the Edgar system, and you need to do one small case study. Please check that once you finished watching the video and reading this chapter. So now here we'll learn about another statement. It's also a periodic statement, and usually you will find this statement with the annual reports, which is known as the proxy statement. Shareholders or the investors are the owner of the company, so they should play the important role to make any company's decisions. But it will be very difficult to assemble all shareholders at any one time or at any one place, because usually shareholders or stockholders, they need to approve any company's decisions. They have the right to cast their vote, especially if they need to elect the board of directors or any major decisions. So it is usually impossible. So what companies do, they actually send a proxy statement with their annual report, and the shareholders need to sign the proxy statement and send it back to the company. So this proxy statement basically is giving the power back to the company, and they are mentioning that on behalf of these stockholders they can take any decisions. So basically here, when the companies send the proxy statements, the shareholders actually grant the legal authority to cast votes for the owners in connection with various actions to be taken at the stockholders meeting. So since this proxy statement actually conveys the power and decision making power or voting authority, so SEC also required that it's the regulation 14A, that the firm needs to file this proxy statement with SEC at least 10 days before they distribute the proxy statements. So this is another type of requirement, since this is really important to convey the authority, voting authority. So SEC wants that all firms will submit or file their proxy statements. Now here the last item is about electronic data gathering and retrieval systems, which is also known as the EDGAR system. And basically SEC started this electronic data gathering in 1984. So they developed an electronic data gathering systems, and gradually it was developed, and now it is a very nice, great, technically advanced systems where all public companies file their financial reporting, 10K, 10Q, 8K proxy statements, and they have a specific form. It's some sort of like the input the data, and then the system will process the data, and the system will produce the reports, and it makes all financial reports kind of in the same format, which is very good for the investors, especially for comparison purposes. And of course it reduces all those like paperwork, right? So can you imagine if SEC requires to submit all like paper filing, so it should be huge, right? And that's why they started this electronic system. So you need to be familiar with this system. So I'd request, please read this chapter, know about these SEC's requirements, registration process, periodic filing process, know about all these Securities Exchange Commission acts, especially the Sarbanes-Oxley Act and PCAOB, and practice the multiple choice questions end of this chapter. All of the solutions are on Blackboard, and do your case study 1, where you need to find a company through these EDGAR systems, and you need to answer certain questions related to some periodic filings. And that's all about our topic this week, which is financial reporting and the Securities and Exchange Commission. If you have any question, please feel free to send an email to me.